Hello and welcome to this BMA law webinar, Buying an Investment Property. My name is Linda Kirk and I am a solicitor and director of Adkirk Law. Today we're going to look at and discuss how to purchase your investment property, how to source the right property, the different types of mortgages that will be available to you, and then finally we'll look at some useful tips. BMA Law is an independent law firm established by the British Medical Association, offering expert, cost-effective legal advice. Unlike other law firms, we operate on a not-for-profit basis, reinvesting any surpluses back into services for doctors. BMA Law have partnered with Adkirk Law Conveyancing to provide its members with a friendly and personalised service that is fast, efficient, starting with a no obligation quote. BMA Law members will receive our premium service, which enables members to speak to their solicitor at any time outside of normal working hours, including weekends. You will be provided with a direct contact telephone number for your solicitor, including a mobile number, so you can call directly. There are also discounted rates for first-time buyers, as well as special rates for additional services such as lease extensions, title splits, and other non-conventional conveyancing services. So I'm just going to start now and discuss with you how you should purchase your investment property. One of the first things you need to do when buying an investment property is to have a discussion with your accountant and decide whether to purchase the property in your individual name or set up a company and purchase the property in your company name. Your accountant will explain the different tax implications and tax advantages. From a conveyancing perspective, there are additional processes that we have to carry out if you buy in the name of your company. So the legal fees will be more expensive. This involves checking the company structure, doing anti-money laundering checks against the directors and shareholders, arranging independent legal advice, which needs to be provided for any guarantors that have to give a personal guarantee for the company mortgage. And at the end of the transaction, we have to register the mortgage at company's house before we can register it into your name at the land registry. One important point to note is if you buy a property in your individual name and then decide at a later date to transfer it to your company, the transaction will then have to be for consideration. So it would have to have a monetary value, and you would then have to pay stamp duty on the market value of the property, regardless of what the consideration is. So it's really important that you make the right decision at the outset. If you create a company, please remember you need to comply with the Companies Act, and you will have to appoint an accountant to deal with all procedural requirements of running a company. I just want to talk now about the differences between purchasing in your individual name and a company name, because there are lots of benefits and disadvantages to both. So first of all, the stamp duty on a purchase. So if you buy in your personal name, it is the standard residential rates plus the second home surcharge. If you purchase in your company name, you pay the higher rates, including the second home surcharge. When it comes to mortgage interest relief, you are restricted if you buy in your individual name. You only get 20% tax credit in the UK for your mortgage interest, whereas in your company name, you will take advantage of the full deduction of the interest as a business expense. So far as mortgage rates are concerned, generally the rates are much lower if you buy in your personal name, and there are lots more lenders to choose from. If you purchase in your company name, The rates are higher and there are fewer lenders available on the market. When it comes to the deposit requirements, if you buy in your individual name, you are likely to require a 20 to 25% deposit, whereas purchasing in your company name, you will need between 25 and a 40% deposit. Looking at the tax on the rental profits. So if you buy in your individual names, you will pay tax basically on your personal rate. So if you are a higher rate taxpayer, then you will pay tax on your profits at the higher rate. Whereas if you buy in a company name, you'll pay corporation tax, and currently corporation tax is lower than your personal tax rates. When it comes to withdrawing profit, then if you buy in your individual name, you're taxed when earned, and there's no further tax if you keep it personally in your name. When you withdraw profits from a company, you're taxed in the company, and then you're taxed again on any dividends or salary you will take from the company. Looking at the tax you pay on the sale of a property, which is capital gains tax, as an individual, you would be able to take advantage of reliefs. There are exemption and reliefs to you as an individual, whereas in your company name, there are no reliefs. You would pay corporation tax on any gain. When you look at the inheritance planning, it's more complex to transfer property when it's in your individual name for inheritance tax planning, whereas when it's in your company name, you can transfer company shares in stages, which assist you with your estate planning. Looking at the liability to you personally, you're liable for debts unless you're covered by insurance, whereas in your company name, liability generally is limited to the company's assets. So really, I would conclude that it very much depends on your long-term portfolio growth as to whether or not you want to purchase in your personal name or in your company name. So if you're only looking to purchase a couple of investment properties, then it's probably going to be better for you to have them in your individual name. Whereas if you want to grow your portfolio and have many investment properties, then you're much better considering the company option. So we're now going to look at finding the right property. So the most conventional way to purchase a property is via the estate agents or online. There are many different types of properties you can purchase, for example, houses, flats, new builds, and you will often find when you're looking for investment properties that there are new build off plan purchases. When deciding what property to buy, it is important to consider the amount of rental income you will be able to obtain for the property. And obviously, if you look to buy a flat or apartment, you will have service charge and ground rent to pay. So you need to consider that because that will be your liability and will come out of the rent that you will obtain. Also, when buying a flat, you need to consider whether it will be affected by the Building Safety Act. This fact is determined by the number of floors and the height of the building. There are a number of these properties which will be subject to works that are required to rectify cladding issues, and they can be problematic to purchase. In addition, there is no guarantee that the regulations will change in the future, and you may find yourself in a position where you have to carry out further works to the exterior of the building. The rules around these types of properties are very complex, and I do not intend to deal with this in this webinar, but it would be very prudent of you to check the position before agreeing to purchase this type of property. There are a number of off-plan new build purchase properties on the market. With this type of purchase, you will need to check what deposit is payable and whether the deposit is covered by the new build warranty. Due to the length of time it will take to complete the property, you need to ensure your deposit is protected. Often you will find with these schemes that you are required to pay more than the standard 10% deposit, and further deposits are requested from you during the course of the build. And such deposits are not protected by the warranty. Anything over a 10% deposit would not be protected by any warranty. And the reason they actually do this is because the deposits are being used to fund the build. I really would not recommend you purchase this type of property, because should the developer go into receivership during the course of the construction, you will lose the monies you have paid. I have a client who I have acted for many years, bought quite a number of properties for, and he actually came to me and asked me to buy one of these properties, and I had to say to him, I'm sorry, but I don't recommend you do that. He went away and got somebody else to act for him in the purchase, and then came back to me about 18 months later and said, I wish I'd listened to you. I've actually lost £220,000. So you need to be very careful if you're buying a property off plan. You may wish to consider purchasing a property via the auction. Often auction properties are cheap and look like a bargain. Please be aware that often properties sold in the auction can have issues, and it would be prudent to have the legal pack checked before you attend the auction to bid for the property. We actually offer a pre-auction check, and if you're successful in purchasing the property, the cost of the pre-auction check is deducted from the legal fee. So effectively, it will be cost neutral to you. You should also have the property checked for structural issues and ensure there are no issues that would be costly to you or that you're not aware of. Often you will find properties in the auction which do have certain issues, such as short leases, structural defects, planning issues, and sometimes I've seen properties that have a mine shaft underneath them. So if they can't sell them on the open market, they then put them in the auction and see if they can get rid of them there. So you do need to be mindful that you can have problematic properties. That said, there are a lot of probate properties that are put in the auction because they just simply require a quick sale. So you can get a bargain, and I'm not trying to put you off buying a property in the auction. I just want you to be mindful that you need to do your homework before you purchase at auction. There are two types of auction. We have the modern auction and a traditional auction. Looking first at the traditional auction, these are where you attend the auction in person, or you can do it remotely on the telephone if you are unable to attend, and somebody at the auction company will bid for you whilst you are on the telephone line. These properties are advertised in advance of the auction date, and you can view the auction pack and download it from the internet. You can also make appointments to go and have a look at the property. At the auction, you will bid for the property, and if your bid is successful, the property is sold to you as the hammer goes down, at which point you will be asked to pay your 10% deposit, and the contract immediately becomes legally binding. You would not then be able to withdraw from the purchase without losing the 10% deposit you have paid. The second type of auction is what is known as a modern auction. Companies like I Am Sold operate this type of auction. If you are successful bidding for a property in this type of auction, you will be asked to pay a reservation fee, which is several £1000s. You need to be aware that this reservation fee is not deductible from the purchase price and is effectively used to pay the agent's fees for selling the property. You are given exclusivity for 56 days to exchange and complete your purchase of the property. If you do not do so within the 56-day period, the seller can remarket the property. If the property was sold to someone else or you decided not to proceed for whatever reason, you would lose the reservation fee you had paid, as this is not refundable. So please ensure you check the type of auction and terms before you bid for any properties, as these may vary. So just to conclude really, the difference with the two types of auction is if you go to a traditional auction, then you can't get out of the contract because it's legally binding at the point that the hammer goes down. So you would lose your deposit. With the modern auction, it's not a legally binding contract when your bid is accepted, but you pay that reservation fee and you would lose the reservation fee if you didn't go ahead. But you've not got a legally binding contract till you've done all the due diligence, which you can do during the 56 days period you've got exclusivity of. Repossession properties often appear attractive and often look cheap because they generally need quite a lot of work and are in poor condition, because people tend to rip out kitchens or take things out and they're in poor condition. When buying a repossession property, the seller will never remove it from the market for sale until you physically exchange contracts. At any time during the course of your purchase, they can accept higher offers and sell to someone else. This means you will incur survey costs, search fees, legal costs, knowing very well you may get gazumped. The reason for this is because the seller, who is usually a lender or trustee in bankruptcy, has to achieve the best possible price for the property. You need to therefore move very quickly if your offer is accepted, and get to the point of exchange as soon as possible. You also need to check carefully the contract and transfer deed, as sometimes there are conditions which allow the seller to have access to the property for a certain period of time after completion. The reason for that is they need to have valuations or surveys carried out. Recently, I had a situation where the lender selling the property had a contractual provision providing that the purchaser could not sell the property within 12 months of completion without their consent. A restriction was placed on the title to this effect, and basically if the property was sold either with or without their consent and the sale price paid for the property, the price they sold the property for exceeded the original purchase price, they had to pay the difference between the original purchase price and sale price to the seller. It was my client that actually purchased that property, and they didn't ask me to check the auction pack prior to bidding for the property. And it was a traditional auction. So their business model was that they did the properties up, flip them and sell them. And unfortunately, they couldn't sell it for 12 months. So whilst repossessions can look attractive, you need to be careful there are no restrictions, and mindful you might outlay monies and be gazumped. We're just now going to look at mortgages, the different mortgages available to you. So firstly, looking at mortgages available to you if you buy in your individual name. There are many products available on the open market, but it is important to instruct a a mortgage broker who has access to the whole of the market, as they will be able to source the best products for you and the lowest rates available to you. They will also be mindful of each lender's requirements and criteria, as they are all different, and sometimes a certain product is not suitable for you. So if you go and instruct a mortgage broker, this will save you time and ensure you only apply to a lender whose criteria you can meet. When buying in a company name, you will need to apply to a lender who does company mortgages, and not all lenders do. All lenders will ask you, when obtaining a mortgage in your company name, to give a personal guarantee. The lender will require you to take independent legal advice before signing the guarantee. This means you have to instruct another solicitor who is not acting for you in the purchase to provide you with this advice. Most lenders now will accept a different solicitor in the same law firm who is acting for you in the purchase. However, there is an additional fee payable for this advice, and you are not normally made aware of this until your mortgage offer is issued. You will also find that some solicitors will say they don't want to provide the independent legal advice because they deem it a conflict. So then you're left going to find an independent solicitor who can provide you with that advice. Some lenders may ask you for a debenture or fixed and floating charge to be taken over your company when taking a company mortgage. This type of mortgage will charge all your company assets, including not only your property you're purchasing, but all your bank accounts, insurance policies, and other assets that your company may have. If you have a debenture over your company, this will contain what is called negative pledges, which means that you will need the consent of that lender who has the benefit of the debenture to any future borrowing. So if you go to buy another property and take another buy-to-let mortgage, you will need their consent. And it just slows down the transaction and is just a little bit messy. Bridging finance is another type of finance available to you when purchasing. This is a mortgage which provides a short-term finance, and generally the mortgage term is 12 months. You will need to be able to repay this loan at the end of the term, or else penalties will apply. Sometimes you can apply to extend the loan, but you will need to meet the lender's requirements, and there will be additional costs payable for the extension, and they are extremely expensive. And in view of that and the short term, you need to ensure that you have at the outset a clear exit strategy and know how you're going to repay the loan before you take it out. This type of mortgage is often used where properties require works to be carried out and they're not acceptable to the high street lenders. So you need to carry the works out first and then look to remortgage it to a high street buy-to-let lender and repay the bridging finance. One factor you really need to be aware of is the interest on a bridging loan is front loaded, and it is not paid monthly like on your normal high street lender mortgages. This means the interest for 12 months is taken from the loan amount at the outset. So if you was to borrow £100,000 to purchase a property, and the interest for the 12 months was, say, £20,000, they would only release to you £80,000. They wouldn't release the full amount. It happened to one of my clients. Well, it was somebody I actually knew, and they took bridging finance because they were doing a self-build mortgage. They were doing building a property, and they wanted the finance before they completed the self-build mortgage, and they were quite shocked when it come to completion that they didn't get the full loan amount because they deducted the interest. So I just thought it's quite an important point really to make you aware of. So, when purchasing a property which is not your main residence, the number one thing really is you will pay the higher rate stamp duty, as we discussed earlier. There is a stamp duty calculator and on HMRC's website, so you are able to check what the level of stamp duty will be for your particular purchase. Since they reverted the stamp duty at the end of March back to the current rates, it does actually make quite a difference. So if you're buying quite an expensive buy-to-let property, the stamp duty is expensive. It is important that you keep records of your property income and associated expenses, including costs of repairs and improvements, as these may be offset against the tax you pay, and they may also be offset against the capital gains tax you will pay when you sell the property in the future. Again, important you discuss these with your accountant, and they will provide you with far more detail on this. It is also important to ensure your tenancy agreement is properly drafted. Most lenders require you to rent the property out under an assured short hold tenancy. And it's important that you follow your lender's requirements when renting the property out. These will be set out clearly in your mortgage offer, and their terms and conditions will specify their requirements. You must also ensure that you are legally compliant as a landlord. You will need to comply with the rent a property requirements. You'll need to have up-to-date gas and electrical certificates and ensure you renew these when they expire. You also need an EPC. You will need to put the deposit in a government tenancy deposit scheme and give your tenant a copy of the how to rent checklist. You also need to check the tenant has the right to rent your property, and I would strongly advise you to have appropriate insurance in place. Please be aware, if you do not follow the above requirements, this may affect your ability to terminate the tenancy in the future or evict the tenant in the event that they don't pay the rent. Finally, once you have completed your purchase, as this is a property you will not reside in, it is really important that you protect your property from fraudsters. Property fraud is continually on the increase, and in order to try and reduce the risk of this, you must ensure your contact details are registered on the Register of Title, and that it is your current address and not the property address. You can register up to 3 addresses on the register, so you can include email addresses. I would strongly recommend, with it being an investment property, that you take advantage of the 3 addresses, because what will happen is if there is any activity on your title or the land registry need to contact you, they will contact you on all 3 addresses. Please remember, if you move, you must update the land registry title with your new address so that they have your latest information. You can also register a fraud restriction. A fraud restriction will require the solicitor acting in the sale of the property to provide a certificate on completion to confirm that they are satisfied the person selling is the legal owner. You can also sign up to property alerts, and the land registry will then alert you to any applications made against your title. I would strongly recommend that you do this because you will have no knowledge if anybody writes to you at the property. And you need to be aware of any activity at the land registry, because a lot of the fraudulent transactions are where tenants try to clone your identity. So the property alert option is a good option. So that brings me to the end of this webinar, and we're now going to move on to the questions. I just want to let you know that I will contact you all at the end of this webinar, so that you're free to ask me any questions moving forward that you may have. So, the first question, I have a few buy-to-let properties bought 15 years back. The one in London has been in the sales for 12 months. I'm advised to consider placing it in a modern auction as it's not been sold. What are the risks with this method? Well, I think as a seller, there aren't really any serious risks to you because the buyer will pay your fees. I think the only thing you need to be aware of is that in the modern auction, it's not a real legally binding contract when you accept their offer, and they have 56 days in which to exchange and complete. I did actually recently have a client who sold in a modern auction, and the buyer did not exchange within the 56-day period. And he came to me and said, "Where do I stand? I've sold it at auction." And I said, "Well, actually, the only benefit to you is that you can now remarket the property on the open market after 56 days. So really, from his perspective, it was not great because he didn't have a legally binding contract, and I think he really thought he'd sold the property and they couldn't back out. So that is the disadvantage to you, is that they've got 56 days to commit. But I think you can take some comfort from the fact that a buyer is paying a reservation fee, which is several £1,000s, and nobody would do that without really being committed to the purchase. I have an investment property and would like to remortgage. So that should not present you with a problem. I'm not sure if that property is in your individual name or your company name, but as discussed in the webinar, there are lots of products on the market if it's in your individual name. And again, there are products available to a company. So my advice would be to instruct a mortgage broker who can source you the best possible products and rates that are suitable for yourself. Is buying property through limited companies useful in view of inheritance tax situation? In short, I would say yes. Obviously, it is a question for your accountant. It's generally much easier to dispose of your properties for inheritance tax purposes if they're in your company name. Is there a link for the meet? Oh, right, sorry about that. I can confirm that you will get the slides, and it is being recorded, so you will be able to get a copy of the recording. Can property income loss I have built up in the past be offset against my share of limited company property income profits? I can't really answer that question for you because it's very much your accountant that should be answering that. Obviously, sometimes you can benefit from losses, but it will very much depend on the situation. I would advise you to contact your accountant. Will you be able to help with special cases where the house was bought as a main residence, but when moving out decided to make it an investment property and transfer to a limited company? Yes, absolutely. This is something we do deal with. I did touch on it in my presentation because you will have to pay. The long and short of the issues are really you will have to pay stamp duty, but you need to look at this and see what is best for you in the long term. And quite often, moving it from your individual name to your company is a benefit in the long term, and paying the stamp duty, you will recover that in the long term. Again, I'm happy to discuss that with you. It is a conversation you also need to have with your accountant. Is there a way to get around stamp duty if you live in it as your main residence for e.g. 6 months, then want to rent it out? Yes. Basically, if you do move into a property and deem it your main residence for in excess of 6 months, it is classed as your main residence. However, if you sell it, you will obviously pay stamp duty on at the standard rate on your next purchase. If you then live in it and rent it out and go and buy a new property, so long as that is deemed your main residence, you will pay stamp duty on your new residence at the standard rate. If you lived in your property for over 7 years and moved to a bigger house, can I transfer my older property into a business? Are there implications on stamp duty and capital gains? Obviously, tax implications need to be discussed with your accountant. You can transfer your property into your company, but as discussed previously, it has to be for value, and you will, whatever the value is, you will pay stamp duty at the market value. But you need to look at the savings that you'll benefit from moving forward and see if it's worth your while doing that. Is it possible to obtain a business loan to purchase property through a limited company instead of getting a mortgage? I have seen that done, yes. It is possible to obtain a business loan. I would recommend that you speak to your account manager at the bank and see what different products are available to you. You may find that the interest rates on a business loan are higher than what they would be on a mortgage. But again, that's something that your bank will be able to help with. And also, I would recommend you contact a mortgage broker and see what products are available. I think what you need to be mindful of, if you go to your bank, they will tell you what products are available on business loans. But when it comes to mortgages, they will only sell you their products. They won't go to the open market, whereas a mortgage broker will go on the open market and see what's available with other lenders as well. I have 117 years lease left on buy-to-let property. Should I consider selling? So 117 years is fine. It shouldn't present you with a problem. It's mortgageable, it's saleable, and it wouldn't become an issue until it dropped really to around 80. I would say around 90 years. 85 years is really the point where they become problematic. 80 years is very problematic because it increases what is known as the marriage value. So extending the lease then becomes expensive. So at the moment, it's absolutely fine. It won't be a problem for you to sell it. But if you want to keep it, it depends how long you want to keep it. If you're going to keep it for 5 years, no problem. If you start keeping the property and it gets down to 90 years, I would say that you would be asked to extend the lease at the same time as you sell the property. When it comes to lease extensions, it is a complicated calculation as to the cost. and it depends where the property is. It also will depend who your landlord is. So if your landlord is a council, you will find that the councils are really quite ethical with extending leases. If your landlord is a private landlord, they basically see an opportunity to get as much money as they can. And they're not quite as flexible when it comes to negotiating the premium. There are different ways of extending a lease. You can do it under the legislation or you can do it voluntarily. But at the end of the day, if you're going to extend the lease, I would advise you to get a valuation done at the outset by your own surveyor and see exactly what they value it at. Because you will need to have a valuation done to be able to go down the legal process to extend it. So it's the best way to start the lease extension process. Um, my buy-to-let property needed work doing, and other freehold shareholders want a license to alter, even though surveyors have not found any issues with the works undertaken. What do you suggest we do? Well, this will very much depend on what's in your lease. So with a lot of leasehold properties, so flats and apartments, the lease will specify that if you do any alterations, you require the consent of the freeholders. The wording of the lease is crucial, really, because sometimes it depends how it's worded, whether or not it affects the alterations you do. But in the majority of cases, I would say you do need consent of the freeholder. And if they require a license for alterations, then you will have no alternative but to enter into it, because your failure to do that would mean you would breach your lease. So I think the first recommendation is to check your lease. More than happy to try and assist you with this, but it's not really a matter for your surveyor to decide whether or not that is a requirement. It is a legal requirement under the terms of your lease. And like I say, if you don't do it, then they can deem that it's a breach. And if you're in breach of your lease, well, it's quite serious. So I would not recommend you go down that route. And I would recommend that you check your lease and comply with the requirements in the lease. I don't think I have any more questions. Unless anybody has any questions, I'm more than happy to help with them. If there are no more questions, then that will bring this webinar to a close. Thank you.